The Kentucky Supreme Court is one of the most influential institutions in the state. Established in 1975, the Kentucky Supreme Court makes decisions and rulings that impact the lives of Kentuckians. Decisions that can help and hurt businesses and the quality of healthcare provided in the state. When you go to fill out your ballot on November 8th, you may notice that you get to choose who you want to see on the Supreme Court. Unlike at the federal level, where the president appoints a Supreme Court justice, Kentucky allows for the direct election of Supreme Court justices, giving you a direct say in the final decisions of our court system. Kentucky Supreme Court has 7 nonpartisan justices who are each elected to serve 8-year terms, and each of those justices represents one of 7 Supreme Court districts in the state. This November, Kentuckians in the 5th Supreme Court District, which covers 11 counties in central Kentucky, will see 2 names on their ballot for Supreme Court Justice, Glenn Acree and Larry Van Meter, who are both running to replace retiring Justice Mary Noble. The Kentucky Chamber of Commerce and the Partnership for Common Sense Justice are happy to pull back the curtain on the Kentucky Supreme Court and encourages voter participation in judicial elections to promote a more fair and balanced justice system. I sat down with both judges to talk to them about their campaigns and their motivations for running. We begin with Judge Acree.
My name is Glenn Acree. I'm running for the position of Justice of the Kentucky Supreme Court. I'm currently on the Kentucky Court of Appeals and recently just finished 4 years as Chief Judge of the Kentucky Court of Appeals. I come from Metcalfe County, but I was actually born in Baltimore. We moved from Baltimore back to Metcalfe County, my father's home, when illness caused him to lose his job, lose our home, and we moved back into the house actually in Metcalfe County that my dad grew up in. And so that's where I finished high school. From there, I joined the Army, went to graduate school at the University of Maryland, got a master's there, and while I was there, my brother-in-law suggested I consider law school. I was the first one in my family to go to college, so he thought what you're supposed to do if you're in more than one, if you get more than one degree, he thought one of them should be either a doctor, you should either be a doctor or a lawyer. So I considered law school and haven't regretted it since. It's given me the opportunity to help people, to do justice, and it's been intellectually fulfilling. So that's how my career went.
So obviously you have a passion for the law.
I love researching it. I love writing it. I love seeing other people's views on it and trying to reconcile my own and sometimes changing my own view about the law based on what other people say.
So I guess that's why you decided to run for this type of position, correct?
I'm running for this position because, frankly, I think we need some leadership on the Supreme Court. Not that they aren't wonderful people, but we can't just be judges who ride the bench and write opinions. There's so much more that we can do. If our justice system of tomorrow looks like the justice system today, we have a lot of problems.
Now, in terms of the Supreme Court, and really courts in general, what do you see as the primary issues facing business and healthcare providers in the state currently?
Well, I do know that the Chief Justice has mentioned the need for specialty courts, and we've used specialty courts in a variety of ways. We are at the very inception of discussing specialty courts for business and commerce. Because the truth is, there are a lot of judges who have never experienced what it is to run a business. Or really ever been in a business. The struggles involved in running a business and satisfying all the regulatory needs, that's a maze to have to negotiate.
Now, to what extent should a Supreme Court justice consider, the business community and healthcare providers, in making their decisions?
There was a Supreme Court justice from Kentucky who said that the law should be predictable enough that knowing men, of course today we would say men and women, but so that knowing men could order their lives. And if that's true with men and women, it's certainly true with businesses. Businesses need to be able to predict things. We have a not great climate in Kentucky for business. We were 38th in 2014 and 39th according to your all statistics in 2015. We're going in the wrong direction. And we may be going even further in the wrong direction with this recent Tibbs versus Bunnell case, because that was not addressed by the Supreme Court of Kentucky, and it may be a bit devastating on medical practitioners. But if you're myopic in your approach and you're not considering the grand fabric of our jurisprudence and where the case fits in that, you're not really helping a practitioner be in a position to advise his client. not only should we consider how this case fits in the fabric of our jurisprudence, we have to be mindful of how it affects society. I'm not saying we should be guided to direct, we're not trying to affect the course of societal change, but we should be mindful that our opinion has an impact on it. It has an impact on the family. It has impact on business.
What improvements do you think should be made by the Kentucky court system to improve inefficiencies, especially with civil cases?
So one of the recommendations of the National Center for State Courts is to have this three-track system I was telling you about, which allows you to go back and forth. But one of the key elements of that is the court would be in control of the speed at which it takes place. So you would take away the ability of lawyers to drag out litigation. Having been a lawyer for 21 years, I know that's not going to go over real well with lawyers. They don't like to not be in control. Lawyers and judges like to be in control. So if we take that away from the lawyers and give it to the courts, there'll be some blowback. So we have to sell that.
Now that you've gotten to know Judge Acree, we now hear from Judge Van Meter on his background and the election.
So I'm Judge Larry Van Meter. I grew up in Winchester. I'm a judge currently on the Kentucky Court of Appeals. I've been on Court of Appeals for 13 years. Before that, I was a judge of the Fayette Circuit Court. Before that, I was a judge of the Fayette District Court. And before that, I was an equity partner at a large law firm in Kentucky, Stahl, Keenan & Park, where I practiced transactional law, which basically is a way to say that I worked in equine law, business organizations and planning, taxation, real estate, trust, probate, estate administration, estate planning, basically transactional practice where my job was to help people realize their goals, whether they were business, professional, personal.
So you've been in law a long time.
I have for 33 years.
So I'm guessing that's kind of why you were ready to take this next step and run for this role.
Right, exactly. And so what I think is why am I running for the Kentucky Supreme Court? The reason I'm running is that I think my background, both in law practice and as a judge for over 22 years at 3 levels, District Court, Circuit Court, Court of Appeals, gives me a unique background to qualify me to do the job, not only to do it, but to do it well.
Now, in your opinion, how much, should a Supreme Court judge weigh the priorities of the business community and healthcare providers when making decisions? How much should you think about that when making a decision?
Okay, and I've thought about this as well, and I know probably what the answer might want to be, but truly, we're not advocates. We're sort of like the umpires in a sports contest. We're there to call the balls the strikes, to enforce the rules. In any given case, the outcome might be disappointing to a given business, but I think long-term what businesses want is they want certainty and predictability in the ruling. They want a uniform body of law. Personally, I agree. I want Kentucky to have a pro-business climate, to low taxation, one that is friendly to business formation, relocation, low taxes, great transportation, takes advantage of our location in the middle of America. But truly, those issues really are legislative issues and executive branch issues, and that's not what I'm running for. I'm running to be a justice on the Kentucky Supreme Court, and again, that's our role, is to adjudicate what the law is and to provide long-term stability and predictability for the Commonwealth.
Now, what type of policies do you think should be adopted by the Kentucky court system that, will address some inefficiencies, especially with civil cases, civil matters?
Okay, I've thought about that, and really what the question is it addresses the fact that litigation is expensive, it's long, and it's stressful. It's stressful for litigants, and I know that. 2 things that need to be worked through with the General Assembly are uneven allocation of judicial resources and family courts. As a court system, though, one thing we could do is amend civil rules. One thing is to adopt the proportionality rules that have been adopted by the federal courts to make discovery attuned to the needs of the litigation and the resources of the parties. That could be done. We should dust off the expedited docket litigation where those rules are actually in place, but they've only been adopted in a number of circuits. Now, some some judges and some attorneys think not every case needs to be on an expedited basis, but certainly there's a place for those rules, and they need to be further dusted off and considered and maybe put into place in more places. We have e-filing. We need to make that more streamlined, more efficient. We need to have it apply to the appellate courts. We need to make it truly seamless like is in the federal system. One thing we could also do is we could provide for telephonic or Skype type motion practice or pretrial hearings. A lot of attorneys practice over a wide geographic area, and so if an attorney's in Louisville, Lexington, or Northern Kentucky, or any other place in Kentucky, but they have a practice that takes them to more remote parts of the state from where they are, if they didn't have the travel, you can't really work when you travel, but you have to bill for it. So clearly that is another expense. And if you could provide a rule to make those more functioning in terms of telephone or Skype, they just would save that cost.
The Kentucky Supreme Court election will be held on November 8th. You have a voice. Make sure our judicial leaders hear it with your vote.